Welcome to Bar 10 Explanations. How to brief a case. Let's get started. A student brief is a short summary and analysis of the case prepared for use in classroom discussion. It is a set of notes, presented in a systematic way, in order to sort out the parties, identify the issues, ascertain what was decided, and analyze the reasoning behind decisions made by the courts. Although student briefs always include the same items of information, the form in which these items are set out can vary. Before committing yourself to a particular form for briefing cases, check with your instructor to ensure that the form you have chosen is acceptable. If you take a look at different case brief examples, you would see that they are all different, but they do have the same components. These components are important as they contain relevant information about the cases, which you would have to find and write down. The very first component would be who are the parties involved in the case. You can identify the parties either by name or by the titles based on their roles in the case. If you'd like your brief to be more specific, you can use both the names and the titles of the parties who are involved. Additionally, you should include the court that heard the case. There are different kinds of courts who can hear cases, such as state courts, federal courts, the Supreme Court, and intermediate appellate courts. The citation is basically the information which would state where the case was published, and it should be included in your brief. This is added so that the reader of your brief would be able to easily find the original file for the case. The above citation gives us information about a case called Furman v. Georgia, which was decided in 1972. It can be found on volume 408 of United States Reports, starting on page 238. So we got all that information about a case out of just one line of citation. The procedural history or posture, simply put, is the history of the whole case. It would contain the different courts the case was heard in, all the events during previous court proceedings, and how the case arrived at the most current court. The facts section of the brief includes all the necessary facts and context facts. Necessary facts are those which are legally important, while context facts are those which would help you understand the necessary facts. To be able to give a clearer picture of the whole case, both kinds of facts have to be included. Law school case outlines generally follow the IRAC method. This anagram stands for issue, rule, analysis, and conclusion. The issue is the legal question being presented in the case. Generally, the best place to look for this is in the judge's decision, as it usually presents the question to be answered. In essence, it may make sense to begin reading a case from the decision on. You may also find the issue within the fact scenario as well. The rule section of the brief cites the general rule applicable to the issue. The rule should be specifically stated in your brief. The analysis section of the case brief may be the most important, because you must understand the court's reasoning to analyze it and to apply it to other fact situations, such as those on the exam. Starting with the first issue, describe each link in the court's chain of reasoning. In the conclusion section, we apply the analysis to the general rule, we discuss any exceptions and how they are applied. Finally, we discuss how did the court rule, also known as the holding. Your conclusion should be a brief explanation as to how your analysis and the general rule got you to the current decision. Remember, the outline should be a brief synopsis of the case, but in language readily understandable to you. It should be personalized as best as possible, and should allow you to quickly recall the facts of a given case with very little effort. Do not make the mistake of including too much information in your outline, or making it a rewording of the entire case. The goal is brevity. Thank you for watching Bar 10 Explanations. How to brief a case. We hope this introduction into briefing a case has been helpful. For more help with the roller coaster of law school, please refer to our other Bar 10 explanation videos. And remember, briefing cases is not just for law school. As a lawyer, you will have to read and analyze cases with a careful eye to detail. You also will have to summarize cases when writing legal memoranda, briefs, and other documents, and when making oral arguments to courts. Now, begin practicing and developing your briefing skills. Remember, the skills you develop in law school will follow you to practice.